Yep.
Hi everyone, and welcome to another Foyle Island online event. And I'm delighted that we have Niall Fitzgibbon SC with us today. And he's going to be looking in some detail at the 2019 Consumer Insurance Act. Just to introduce myself, I'm Ian Thornhill, the Ops Manager at Foyle, not Lawrence Bessemer, as the green screen shows. Before we start, just to remind you to make sure you're following our Foyle LinkedIn account. You can find the icon at the bottom of our website. If I can ask you to make sure your microphones are on mute, that would be great. Any questions that you've got for Niall, if you can use the chat facility, and we'll try and get through as many as we can at the end, time permitting. So without further ado, let me hand you over to Niall Fitzgibbon. Niall.
Okay, thank you, Ian, and big thanks to Ian from me and Declan Devereux for providing me with the opportunity of presenting this seminar. I hope everyone's in the mood on a Thursday, balmy Thursday afternoon, to discuss the finer points of the Consumer Insurance Contracts Act, but that is something that we'll have to embrace. Just in terms of my own CV, so I've been a barrister in Dublin for 30 years. I've been a senior counsel for the last 10 years. I suppose relevantly, following my BCL degree in UCD, I did a master's in Cambridge University in insurance law, and then following that came to the bar. So in terms of my current practice, it would be very heavy on insurance company involvement in a number of contexts, mainly UK and Irish insurers. So a lot of policy disputes, declinature, arbitrations arising on foot of that, opinions arising in the first instance as to the validity of declinature. I would act on both sides of the fence in that regard, mainly for the insurers, but also in relation to policyholders who are challenging declinature. And then, of course, recovery claims. I would have a special interest in defamation, which is very often, as a lot of people may not know, is the subject of a good deal of insurance cover in relation to defamation. In fact, the recent Gerry Adams trial that we all would have read about, most people were taking the view that the trial damages and costs itself would bankrupt the BBC, until they helpfully pointed out, which is accurate, that they have full insurance for that kind of thing. So insurance arises across a whole range of aspects, including defamation. And of course, I would do a lot of defence personal injuries work as well for insurers, almost exclusively. So in relation to this particular issue, the structure of litigation, as we know, can go off in different directions. And when we're talking about insurance policies and policies that affect the consumer, and obviously the 2019 Act in that regard, as I say, the usual chronology is provision by someone of an opinion as to declinature, which is usually the trigger. And then you will have litigation, whether by way of arbitration or otherwise, against the insurer. But certainly more and more, in my experience, the litigation can also branch in different directions and very much involved, while it's not technically part of the insurer's concern. More and more, the insurance broker is entering the frame in relation to this kind of litigation. Obviously, I should say something about the broker, because it's quite relevant. In the last three big sort of arbitrations and disputes that I've been dealing with, the broker has entered the frame in terms of liability in all of those instances. The reason being that, of course, that the broker is an insurance intermediary, while they're technically, I suppose, an agent of the policyholder, of the insured. They're paid by the insurer. And it's always a little bit of a grey area as to whom the broker owes their duty. And there is, of course, this concept known as dual agency status, whereby effectively there is an argument that there is duties and obligations on both sides. So two areas where the broker would enter the frame in this kind of litigation, in particular relation to policies, is in relation to the statement of fact, or the proposal form as it used to be known, now known as the statement of fact, which is the key document at the inception or renewal of a policy, in terms of assisting the policyholder as to what to include and not include, obviously all material facts, to check that everything is as it should be. Very, very important. And these are all core provisions in the 2019 Act, which I'll come on to. The second aspect where the broker is entering the flame in a very meaningful way in litigation is in relation to underinsurance. So even if the liability position is set, it may be a 50-50 or whatever the outcome, whether by arbitration, determination or settlement is set, underinsurance will of course affect the quantum of the claim. And again, there is very much a question mark over the role that the broker plays in relation to the issue of underinsurance in terms of the inception of the policy. There's no Irish authority really on that, but there is, for example, a UK authority, J.W. Bolam and Bias in the 2000 Lloyd reports, and that's really the leading authority where it is acknowledged that the broker has a duty to advise the policyholder in relation to underinsurance. So in a property claim, property insurance, valuation on a full reinstatement basis has to be the measure in terms of getting the appropriate insurance to meet the policyholder's needs. So again, when we're talking about litigation, arbitrations against the insurer, against the backdrop of this Act, it is important to take a round view of all of the stakeholders in this kind of litigation, and the broker is very much in the frame, in my experience. Just in the course of my discussion, I am going to deal with two of those recent insurance disputes that I've been involved in. And in both instances, as I've said, the broker has been involved, but more relevantly, and this is really why I choose to deal with this topic in seminars, it's the fact that the 2019 Act, which of course is the forerunner in the UK, would have been the equivalent Act in 2012. It really is of importance because it has a very, very meaningful impact in a number of respects. I'll be dealing with I'm not going to deal with all 24 sections of the Act. We don't have the time, and a lot of them are pro forma and not particularly relevant or interesting. I'm going to be dealing with 4 areas of the Act where it really has a meaningful relevance in litigation and in disputes. And the first is the issue of who does the 2019 Act apply to. So in relation to both commencement date and who is a consumer. I'll be looking at that first. Then I'll be dealing with the issue of pre-contract formation, the statement of fact stage, if you like, at the inception or renewal, a very important stage of insurance. The next area I'll be dealing with is unfair contract terms. Again, a brand new area which was introduced by the 2019 Act of huge significance. And then finally, I'll talk about the direct third-party right of action, which again didn't exist before the 2019 Act. But as I say, in my experience, and it really is quite incredible how we have very proficient parties in litigation and vast insurance companies with expertise. And yet I see time and time again that the 2019 Act, which was implemented and became active in 2021 in 2 tranches, or was it 2020? In September 2020 was the bulk of the Act, and then in September 2021 was the rest of the Act becoming active. So that is 4 years ago at this point in time. And yet time and time I see the Act being not on the radar of both claimants and insurers. relevantly, there is no case law as such in relation to the interpretation of the Act. There's only, in fact, I had the Legal Research Centre in the Bar here in Dublin looking at any and all relevant case law arising from the Act since its implementation in 2020. And there is one irrelevant case. And then really there's only one other case that is of kind of tangential relevance, which I'll be dealing with in due course, a decision in 2022. So it's under the radar. There's basically no case law in relation to some of the key provisions and how they are to be interpreted in an active dispute situation. And against that backdrop, it is very difficult to imagine an act that will have more impact on the outcome of a dispute and the outcome of settlement talks. And the dispute from start to finish will be impacted by the more relevant aspects of the Act that I'm going to refer to. So again, in the two case studies that I'm going to mention, what you had was, so in the first one, which involves a nightclub policy, and if any of my insurers know which case I'm talking about, they can remain anonymized as I am in relation to the identity of the parties are on both sides. It's more dealing with the circumstances and the issues arising in the dispute. In the nightclub case that I'll come on to in a few moments, the policy was dated July 2024. In the other case involving a commercial yard with different premises, the policy was August 2022. And in both of those instances, there was a complete absence of awareness that the 2019 Act applied to the policy and to the dispute. So what you had was, in both cases, a purported declinature of cover. So both cases north of $1 million, as these cases often are, involving business interruption, property damage, etc. Normally very high stakes claims. Both of these cases were well into the 1 to 2 million. And you had an insurance company effectively offering zero on the basis of declinature. Cut to an acknowledgement and realisation that the 2019 Consumer Insurance Contracts Act had application, and that the insured and policyholder in each case was in fact a consumer. You had an offer of zero and a case heading headlong into arbitration or the courts, eventually being resolved, in or around 750,000, 1 million. So that is the impact that the provisions of the Act can have, and it's not to be understated. So in relation to that, clearly the first important issue, as I've just indicated, which is often lost under the radar, is the application of the Act. So to whom does it apply, and who is a consumer within the meaning of the Act? So there is, you should all have access to, or you will have access to, I have a 20-page document or paper on the 2019 Act, which Ian will furnish to you, I think, in full after the seminar. But I think Ian, you're going to share a page in relation to the paper.
Yeah, so, hopefully you should be able to see it on your screen. Definition of a customer up on the screen, hopefully then.
See that, yeah. So I'm cutting to the chase, really, which is halfway through the paper, which deals with, it's kind of the summary of the core aspects of the 2019 Act, okay? And A and B, their commencement and the definition of a consumer is, as I've said, absolutely critical, because it is being missed as a proposition that applies to disputes, even in, as I say, in 2024 cases. So Section A, you'll see there, the Act was commenced into law in two phases, the bulk of the Act commencing on the 1st September 2020. Remaining sections commencing the 1st of September 2021. So the Act only applies to insurance contracts agreed, varied, or renewed after the commencement dates. And you can see here, you see the reference below to renewal spanning the commencement of the tranches of the Act should be identified and noted carefully. So I would have delivered this paper on previous occasions when it was closer to the time or directly after the time when the Act was coming into force in 2020 and again in 2021. Because what you have is, in many cases, as we know, the essence of an insurance policy is that it's renewed every year on tap, practically automatically, with not much consideration coming from insurer and or policyholder, or if so, honoured in the breach, as to various changes that have taken place. And obviously, the first change that takes place is the commencement of the Act, having application to, as I said, insurance contracts agreed or varied or renewed after the commencement dates. So the first thing that I'm looking at when I see a dispute is, when was the policy incepted, and in terms of the policy provisions that apply to the particular dispute, were they varied, renewed, etc.? Are they captured by the Act? And that brings me on to the key point, which is the definition of a consumer. So on the next page then, we have the definition of a consumer contained in section 1 of the Act. And basically, the 2019 Act borrows the definition of a consumer from a different Act in the Irish jurisdiction. You'll see there section 2.1 of the Financial Services and Pensions Ombudsman Act 2017. Clearly done for, it's obviously, we're in the area of financial services and so on. And the definition was simply borrowed in section 1 and is referable to that definition in the 2017 Act. So you'll see on that page that a consumer in section 2.1, and obviously in this Act as well, is defined firstly as a natural person, not acting in the course of their business. Secondly, a sole trader, partnership or trust club, etc. And then this is the tricky one that, as I say, is frequently not considered in the context of disputes, which is an incorporated body. So invariably in the cases that we see, in the disputes that we see, the policyholder is a company, is an incorporated body, which may or may not be a consumer for the purposes of this Act and a legal dispute. So consumer status will apply to an incorporated body that, you'll see 3.1, had, past tense, an annual turnover in its previous financial year within the meaning of section 288 of €3 million or less, and is not a body corporate that's in a member of a group of companies, combined annual turnover over 3 million. So that's for groups of companies. So I would suggest that it is clause 3.1 that is a key proposition as to whether or not a company, an insured company, the policyholder, has consumer status. So the first thing that I will do when presented with the brief in an insurance policy dispute is to look for the annual accounts of the policyholder. Okay. And if they are not there, as they frequently are not, what you're looking for is the full accounts for the previous financial year pursuant to section 2131. And what you're looking at there is the turnover as to whether or not it was under 3 million. If under 3 million, which is very, very frequently the case when you're dealing with private incorporated companies, they have consumer status with all of the benefits that enjoys. And as I've said in my case studies, blissfully unaware of the application of the Act and whether or not, even if you were aware of the Act and its provisions, does this particular policyholder, which is a significant company that may have a turnover of 2.5 million, is nonetheless a consumer and subject to the benefits of the Act. So that's the first matter, I suppose, which requires very special attention, and it's simply to be aware of that particular provision where it comes from, and what we're looking for in relation to an insurance dispute. The second issue that I want to deal with in detail is pre-contractual formation. So again, sections 8, 9 and 10 of the Act, and I hope people have that in front of them, Ian, as well. The 2019 Act really implemented a revolutionary change in terms of what was there before. So we know that for decades, basically the fundamental proposition was that the entire onus was on the policyholder to fill in the proposal form, provide information on an utmost good faith uber ima fides basis. And that was the single and solitary proposition that was there in relation to the provision of information. And so many cases and insurance claims were flatly refused, almost by default, on the basis that there was some aspect of something that was not provided. And we know that the legal test then came into the frame, which again was quite loose and not very prohibitive against the insurer, which is that the test of what was relevant information that should have been disclosed under the case law is it kind of a matter that would have affected the insurer's decision to provide insurance. And that, in a nutshell, was the legal test as to whether or not the failure to disclose this information was a breach of utmost good faith. So that was a simple proposition with a simple test, which has become far more sophisticated and far more loaded in favour of the consumer in what is a Consumer Protection Act. And it is what is provided for in sections 8, 9 and 10 of the Act that transforms this. So the Act, as opposed to the onus being on the policyholder to provide all relevant information, if we consider, and this is really the only point in time where I'm going to consider the sections in detail, so pre-contractual duties at section 8 that you see, if we look at 1 to 7 quickly, so the duties in this section replace the pre-contractual stage of the contract of insurance, the principle of utmost good faith, uber ima fides, any duty of disclosure of consumer, including the duty of the consumer to volunteer information that applied prior. So utmost good faith is gone. The pre-contractual duty of disclosure of a consumer is confined to providing responses to questions asked by the insurer. So the onus and the sequencing has been flipped entirely. It is now insurer providing questions that need to be comprehensive, and then responses must be provided to that. So we see the consumer shall not be under any duty to volunteer any information over and above that required by such questions. Where the insurer requests and the consumer at the pre-contractual stage provide information to the insurer should be under a duty to ask specific questions on paper and shall not use general questions. So not just questions, but very specific. It shall be presumed, unless the contrary is shown, that the consumer knows that the matter about which the insurer asks a specific question is material to the risk undertaken by that insurer or the calculation of the premium by that insurer or both. Where the insurer asks questions, these should be drafted in plain and intelligible language, with the onus of proving that the question are plain and intelligible resting with the insurer. Where there's any ambiguity or doubt, that favours the consumer. The insurer can use the remedies available under the Act if it establishes that non-disclosure of material information was an effective cause of the insurer entering into the relevant contract of insurance on the terms it did. And then the consumer should be under a duty to answer all questions posed by the insurer honestly and with reasonable care. Okay, so that is a seismic change in terms of who was under the principal duty, who has to do the running in terms of the questions, and then who has to respond. Then, as I said earlier, if you were in breach of the uber ima fides, effectively your insurance claim as a policyholder was goosed from the inception. And now what we have is a more nuanced and staggered position, depending upon the nature of, if you like, the glitch in the information that was provided by the policyholder. And most importantly, the remedy, which used to be declinature 100%, is now measured as against the, if you like, degree of misinformation or misrepresentation on that spectrum, which has taken place in a particular instance. So we see in section 9, it deals with the remedies that are proportionate to the effects of any misrepresentation or interest of the insurer and the consumer by reference to whether they are innocent, negligent, or fraudulent. And as you would suspect, if the representation is innocent, that's subsection 2, the insurer has to pay up. Okay. Where it is negligent, that's definitely more, if you like, litigatable, whether something is negligent or innocent. But negligent is obviously where there's an element of carelessness there, but that doesn't measure up to fraud or a deliberate omission. Where that is the case and there is negligent misrepresentation, you'll see at subsection 3, the remedy available to the insurer shall reflect what the insurer would have done had it been aware of the full facts and shall be based on a compensatory and proportionate test. And then, surprise, surprise, if there is fraudulent misrepresentation, the insurer can waive in full. So I just want to deal with my first kind of case study very swiftly. I see that we're half an hour into it already. A recent case that I had, which deals precisely with this scenario. Okay, so what we had was a hotel, kind of a city centre hotel, which had a restaurant and a bar and a basement, kind of a basement bar. And there was an ingress, so there was what was called public house and wine bar cover, was the type of policy for the premises in question. And it was owned by a particular gentleman who then leased out to a family relative the ground floor restaurant area and the basement area, which was a bar. And as it so happened, I'm not sure some of us may be aware of it, the bar was also, in fact, a nightclub for all intents and purposes. So you can see where the misunderstanding, misrepresentation, whatever it might be, arose in the first instance. So you had a lessor coming in for ground floor and basement and taking the same policy that the owner and relative, by the way, of the entire premises had for that particular area. So effectively, the original policy for the public house and wine bar, which were those 2 floors, was continued on or taken over by the lessor, but in their name. So it was a new policy, but it was the same type of policy. So there is an ingress of water that came from Irish Water's mains, causing huge damage. So the property damage is put at 700,000. Business interruption as a result of closure, same again. So you're up to 1.5 million. And what you had was in the statement of fact, there was no acknowledgement or reference to the fact that the basement was a nightclub. And the insurer in question had a dedicated nightclub policy for a significantly higher premium. But obviously it was the public house and wine bar policy which obtained. So a fair point is made by the insurer. You didn't tell us that it was a nightclub. It is. You had the inappropriate policy and were declining cover on the basis that the statement of fact / proposal was inaccurate. So the position was that the statement of fact, and this is the broker is being sued in this case as well, who is meant to advise this policyholder on in fact compiling the statement of fact. A statement of fact is very important for this very reason, and the broker is meant to have a role. As I said at the outset, one of their main functions and duties is to make sure the information is accurate and not containing omissions. What happened here was that the broker, when the policy was provided to the insured, and then a year later renewed, both on the inception of the policy, the public house and wine bar policy, and on renewal, after which the ingress and the claim arose, the policyholder received no advice whatsoever from the insurer and the broker. Nothing, no contact, no advice, and indeed it was the same policy that was in situ when he entered the frame as lessor. So what you're left with there is a policyholder who was blissfully unaware of what he was meant to do with the statement of fact, what he was meant to include, not include, and the nuances and distinction between a wine bar and a nightclub. So declinature has been, obviously full declinature was claimed and proceedings are in being, and these particular provisions are being made both against the broker in relation to a clear breach of duty on the broker's part as to what they're meant to do in terms of advice, and as against the insured. They are claiming full declinature in the scenario that I've just given, where manifestly the claim is being made on behalf of my client, the policyholder. What you're dealing with here is an entirely innocent representation. Okay, the broker may be at fault, but there is an innocent representation, or at the very least negligent, possibly, as distinct from a fraudulent misrepresentation that is grounding the base of full declinature. So that's a case, if you like, that in the pre-2019 Act, this particular policyholder would have no chance of recovering anything, gone. Whereas there is a reasonable chance of full recovery in this case. And even if it's at the second tier of negligent misrepresentation, there is a safety net, as I mentioned at the outset, of linked proceedings against the broker for the clear duty of care that the broker has as a professional to provide advice in relation to the subject matter of the issue, which is the statement of fact and its content. So again, a claim that may be zero is going certainly up to 750 grand and maybe 1.5 million on the basis of this act, and a failure to understand, appreciate, enforce its provisions, and on the broker's part as well. So there's a good example of the impact that the act can have. The next issue that I want to deal with is unfair contract terms, which affects the second kind of case that I have. So this is, again, if we move on to the next page, I think, Ian, under practical implications, section 20. You have that up, Ian, do you? Yeah. Okay.
Hold on. No.
It's, yeah. So it's
is it after case law?
It's after the definition of a consumer. It's on page 10, I think, of the paper.
Okay.
It's into practical implications, unfair terms.
Yeah, got it.
Have that?
Yeah.
Okay. So this was, apart from the provisions that I've just mentioned, was another extremely important change by reason of the 2019 Act, which was the introduction of what was already there. So you'll see in section 20, it refers to the 1995 regulations. So there was a European communities based regulations that were implemented in 1995, but they only provided to, if you like, regular contracts and did not specifically apply to insurance contracts. So the 2019 Act under section 20 applied for the first time those regulations, as you see, shall apply to a consumer within the meaning of this Act. So what we have is the unfair terms, and what do they say? Paragraph 3.1, the regulations shall apply to any term in a contract concluded between the seller of goods or supplier of services and a consumer which has not been individually negotiated. So it does apply just to generic insurance companies. If a policyholder has gone to the trouble of negotiating certain policy terms in relation to whatever it might be in the policy, they do not have the benefit of this act, or certainly as much. What we're really dealing with is you're kind of rubber stamping, you're provided with, as in the example I just gave, you're given a public house and wine bar policy or a nightclub policy pro forma. And there is no individual negotiation engaged with insurer and policyholder. If there is an individual negotiation, the provisions don't apply, or they're more difficult to apply, for the simple reason that you are not really being taken advantage of if you're engaged in the process of actually looking at the terms and making an assessment as to whether or not they are unfair. So subsection 2, and this is the key provision, for the purposes of the regulations, a contractual term shall be regarded as unfair if, contrary to the requirement of good faith, it causes a significant imbalance in the parties' rights and obligations under the contract to the detriment of the consumer, taking into account the nature of the goods or services for which the contract was concluded and all circumstances attending the conclusion of the contract and all other terms of the contract or of another contract upon which it is dependent. In determining whether a term satisfies the requirement, have regard to Schedule 2, and then a term will always be regarded as having not been individually negotiated where it has been drafted in advance and the consumer has not been able to influence its substance, as I've mentioned. And then subsection 5, briefly, the fact that a specific term or aspect of a term has been individually negotiated shall not exclude the application of the regulation to the rest of the contract if an overall assessment of the contract indicates that it's nevertheless a contract as described in paragraph 4. So if there is an individual negotiation, you're up against it, but it's not fatal. Basically, if the rest of an overall assessment says the contract is unfair. And then at subsection 7, there's an indicative non-exhaustive list of examples of unfair terms. So what you have here is what is an unfair term. And the key proposition, you'll see 2 pages on in, sorry, 3 or 4 pages on, that I've referred to European guidance here. Again, there is no case law that I can find related to, so far, the application of this to an insurance contract that has been reported in case law. There is European Court of Justice cases on the regulations as such, which is referred to in my paper, I think 3 pages on, under the heading European guidance. And the European Court of Justice has given a fair amount of, now it's high level stuff, as to the kind of intention of this type of provision. The key points being that a court must, when assessing whether a term is unfair, assess same in the light of all the circumstances attending the conclusion of the contract and determine whether that the term gave rise to an imbalance between the rights and obligations of the parties in favour of the seller or supplier. And that's what the regulation says. And then it says at the next section, question whether there's a shift resulting in the contractual term and the rights of obligations arising under the contract to the detriment of the consumer causes a significant imbalance can only be answered by means of a comprehensive analysis of all the individual circumstances. So you look at the inception of the policy and then all of the circumstances of everything around it. Surprise, surprise. So the case study that I would have in that, which is a case from a couple of years ago. Again, you had, and so this relates to an instance, again, of full declinature, a case that subsequently went before Michael Collins in arbitration, subsequently resolved, and effectively offer is 0, claim 1.3, I think, from recollection, and settled for something like 750, 800. So this was, again, a successful company, a 2-man company, but very successful, that to expand their business in, it was mobile telephony was the kind of the area. They purchased a business park or yard down in Wexford, and they were using it had 10 units in this particular commercial yard, as it was called, and they were using one of the unions as basically a new HQ for their business. But there were 9 other units there, and of the other units, all of it was covered by an insurance policy. The entire premises, in other words, including each individual unit. And there was a fire in one of the units, effectively next to the HQ unit being used by the policyholder. And major fire damage, major claim, and the claim is made to the insurer, full declinature. So effectively, the declinature was based upon a term in the policy based upon occupancy. And effectively, the term, an exemption clause, essentially said that that if there was an absence of occupancy for more than 30 days, so if any of the units, not just HQ, was unoccupied or untenanted, was the expression, for more than 30 days, the insurer was entitled to avoid the policy and decline in the event of a claim. Now, the known position in relation to this particular business yard is that only 2 to 3 of the other 9 units were being leased from time to time, sometimes on short enough leases. The premises, the unit that went on fire next door, wasn't even held under a lease, it was held under a license. So come back to that expression in the exemption clause of unoccupied or untenanted. So it was basically impossible for the insured in this case to comply with that, or to be in compliance with that exemption clause, because and clearly this was an analysis that was not done at the outset. And surprise, surprise, the broker is being sued in this as well, for not taking the care at the outset to make sure that the insurer's policyholders' needs were met in circumstances where you had this arrangement of HQ and 9 units, most of which were unoccupied, and yet you had this offending term where the insured was apparently able to void the policy entirely. So that is a classic instance where you're talking about an imbalance, where the circumstances weren't properly vetted at the time. And what does an unfair contract term mean now under the 2019 Act and the regulations, where there's a significant imbalance between the parties? And the case that was made on behalf of my client in this case was that there was beyond an unacceptable imbalance between the parties, where effectively you could never comply with the requirement that was being relied upon by the insurance company. And again, policy interpretation, etc. The case was resolved somewhere in the middle. And there was another aspect in that case, which is that the insurance that was provided for the unit which burnt down, and indeed most of them, was basically the subject of chronic underinsurance. And I mentioned the broker's duty in that regard, that they are not professional valuers who need to inform what the insurance cover should be, the basis of it on a full reinstatement value, etc. All of that analysis has to be done. But if it is not done, the broker, under the case that I mentioned in the UK, must at least advise that that professional advice is taken. And underinsurance arises very, very frequently in the context of disputes in this jurisdiction. And the broker again enters the frame, and it arose in that particular case as well. So just that is unfair contract terms. Again, you can see, I hope, the very, very clear application to real life litigation that's happening all the time, just as it's happening in terms of whether someone is a consumer, whether a company is a consumer, whether pre-contract formation, has been properly maintained. Is it innocent? Is it negligent? Is it fraudulent, etc.? The role of the broker and the unfair contract terms issue where really the policy terms are so loaded against even a non, in relation to the case that I just mentioned, I should say at the outset that their turnover in the previous year was less than 3 million. Again, no awareness of that on either side until lawyers came into the frame. And it was because their turnover was under 3 million and they were captured by the provisions of this act that they were able to achieve the outcome that they did. The final specific aspect that I want to look at, because it was, again, it's less sexy than the other provisions, but still pretty important, which is section 21 and the third party direct right of action. So again, just turning to under the Act, Ian, section 21. You'll see section 20 there above it in all of its simplicity, a line and a half. So again, section 21 is the right of a third party to claim against an insurer. So it used to be the case that it was extremely cumbersome. If anyone remembers section 2, well, it's still there, section 62 of the Civil Liability Act 1961 was kind of in this territory where basically if you had a claim against a company that went bust, that went into liquidation, but there was an operative policy of insurance at the time of loss, and you were endeavouring to make a claim against that insurer insured entity now in liquidation, it was practically impossible to get an outcome. You had to participate and await the liquidation and winding up process, same for bankruptcy, and it would take a number of years. You had to endeavour to get judgment, I think, against the liquidator from recollection, and then go again in proceedings to recover on foot of what your claim was. So it was impossible effectively in real terms to actually implement. So now what you have is a facility for a third party to claim directly against an insurer in the circumstances outlined in section 21. So where a person, referred to as a person, is insured under a contract of insurance against a liability that may be incurred by the person to a third party, and such a liability is incurred, then when either of the following applies, the person has died, can't be found, or is insolvent, or for any other reason it appears to a court to be just and equitable so to order, the rights of the person under the contract against the insurer in respect to the liability shall, notwithstanding anything in the enactment or rule of law, be transferred to vest in the third party to whom the liability so incurred. So the person claiming has route one against the insurer in circumstances where if the insured party has died, can't be found, insolvent, and indeed there is a catch-all mechanism there. If it appears to a court to be just and equitable to so order, then the right of that person to go against the insurer is direct, which again is an interesting change in approach. So just really to conclude, we've only a small number of minutes left. Really, the key provisions, so there is a paper that's going to be circulated, which is, I think, 20 pages long, and it does refer to everything. It provides an overview in terms of, in particular, relevance to insurers, the intention of the Act, what was there before, the UK provisions, and then on the third page it comes into the key changes. It kind of summarises them, and then it deals with, I mean, there's one case referred to, but in fact it was pre-implementation of the Act, so not very relevant. And it does identify the key aspects, and then halfway in, as I say, are the core aspects that really I've dealt with in today's talk, because, as I say, they really seem to be under the radar, and they have huge implications for litigation and disputes of this type, as I've said now on repeat. So I suppose if there's any questions then that anyone has.
Yes, thanks, Noel. Really interesting presentation there. Yeah, if you've got any questions, put them in the chat. We've got a question from Garrett. So the 1995 Unfair Terms Regulations have been revoked under Part 6 of the Consumer Rights Act 2022. CICA continues to refer to the 1995. Continues to refer to the 1995 regulations despite them being revoked. Which applies? Do you want me to read that again? So
No, I don't. That's a very good question, and I'm not sure I have the answer. I mean, I don't have the revoking provisions and the new provisions in front of me, but if the original provision has been revoked, then obviously the new act is crying out for an amendment in terms of making this particular provision, as opposed to borrowing the definition in the 1995 regulation section 2, to amend it just to directly provide for that in this act. It hasn't come on my radar, Garrett, and I'm not sure if it's come on anyone's radar. It clearly should. I'm not sure if there is any kind of bridging provision in the new regulations that you're referred to, and certainly I'll have a look at that. And if there is kind of a solution to that particular issue by way of kind of a bridging provision, now that Section 20 is gone, refer to this instead and has the same effect. I don't know. It's a very, very valuable point that you've made, and something that I'll have a look at, and we can talk about that down the line.
Thanks, Noel. Right, a couple more questions. We've got so Declan. Presumably a third party acquires no greater rights against an insurer than those of the insured under the policy, for example, policy access.
Yes, that's my understanding of it. I don't see a particular provision relating to that, but that has kind of always been the landscape in terms of that particular issue. Not sure it finds direct provision in the Act.
Okay, another question from Daniel. Forgive me if I missed part of the talk, but will the 3M threshold be changed in line with the new Consumer Protection Code being introduced next year, which raises the threshold of consumer to 5 mil?
Who's to know? I mean, that's a matter for the legislature. Obviously, the consequence, if that change is made down the line, the consequence will be that there will be far more companies that will avail of consumer status. So as opposed to previous year's turnover sub 3 million, it'll be sub 5 million. I'm not sure if that is something that the legislature would intend or wish for. I mean, generally speaking, you know, before anyone considered the regulations, the unfair contract terms regulations, or indeed the provisions of this act, everyone's understanding, and I think it remains the case, hence the fact that these issues, important issues, are so under the radar, is that a consumer is an individual. That was always the layperson's understanding of who or what a consumer is. And it is only when a consumer is framed in terms of a company, an incorporated body specific to the defining criteria of how a company can be a consumer under 3 million or even under 5 million. It's hard to know what view the legislature would take in terms of whether or not they would make that change. I think the gut reaction is that 3 million is a generous enough provision to allow private companies effectively to attain the status of consumer. It would broaden it nearly by twofold if increased to 5 million. So who's to know? Again, that's up in the air, and we'll see how that pans out.
Thanks, Niall. That looks like all the questions. So just leaves it for me to well, thank everybody for attending this afternoon, and a big thank you to Niall for giving up his time today for this presentation. as Niall mentioned, I will send you all his document. Probably come to you tomorrow morning now. And also you'll get your CPD cert in due course as well, which that will follow at a later date. But thanks again, Noel. That was really interesting.
Thank you, and thanks to everyone, and have a lovely evening. Thank you.
Bye-bye.
Bye-bye.
Goodbye, everyone. Thanks a lot.